Okay. Welcome, welcome, welcome. Welcome to Common Law Academy. This is lesson number 10, Authority and Reason, Arguments about Corporate Monopolies, Lobbyists, and Foreign Organizations like the WHO, the WEF, and the UN. We're also going to be talking about sovereignty as well. So, without further ado, let's get into the meat. House rules, veritas pitissima, truth above all, regardless of our wishes, inclinations, or the dictates of our passions. I rely on truth, fact, and evidence, placing truth above all. Make sure you tell the truth. If you're going to interject or you're going to challenge me on something, I love it. Make sure you have the evidence, and make sure that evidence is rooted in fundamental law. Mutual observantia, mutual respect. I will adhere to the golden rule, treating others as I expect to be treated, and loyalty and tolerance. And conlationem gratuity, selfless contribution. I will collaborate and share experiential knowledge for the membership's growth and support. I have no problem sharing all my knowledge with you, but if you have something you can contribute that'll help people learn, be sure to share it with other people as well. Okay, tonight we're going to be using 3 sources, and you're in for a surprise because these are my 3 favorite sources. Starting with 2 treatises on government by John Locke, and then a selection of maxims of law by Charles Weissman, and then, of course, The Law of Nations by Emma de Vettel. So these are very, very important resources of fundamental law, and the address is below on the page. You can go to wepeople2.us and go to Fundamental Law Resources, which is under the Education tab, and you can download all of those resources for nothing. Okay, so today we're going to be talking about the first treatise on government by John Locke of his 2 treatises on government. Now, Sir Robert Filmer was an English political theorist who lived in the 17th century, and he was known for his work, Patriarcha. Filmer argued for the divine right of kings. So he asserted, let me see, somebody just joined. So he asserted that Adam, as he was the creation of God, and he felt he was the only creation of God, at least Filmer did, that Adam had a divine right of being a king. He was an absolute monarch, and all succeeding monarchs in his bloodline, by right of fatherhood, which he had royal authority over their children. This lordship which Adam by command had over the whole world, and by right descending from him, the patriarchs did enjoy, was as large and ample as the absolute dominion of any monarch, which had been since the creation. So Filmer believed that because Adam was the sole person that God created, he believed that he was the sole monarch, and that everyone in his bloodline was also a monarch, and that we needed to do exactly what we were told. He believed political authority was derived from God and passed down through the patriarchal lineage of Adam. According to Filmer, rulers held absolute authority over their subjects, and disobedience to the king was tantamount to disobeying God. Filmer did not believe in the concept of natural rights or the idea that government should be based on the consent of the governed. Instead, he advocated for the preservation of traditional hierarchical structures with the king as the ultimate authority. Now, Filmer's views provided a theological justification for absolute monarchy. Now, John Locke, who was born at the time and who was regarded as one of the most influential enlightened thinkers, and I agree, Locke's ideas had a profound impact on modern political theory. His most famous works include the 2 treatises on government, where he addressed Filmer's views head-on, and he championed principles of individual liberty and popular sovereignty. And here's what At first, Locke discounted Filmer's treatise as he thought it was not serious discourse meant in earnest, so he didn't even take it very seriously. But as people started catching on and reading it, Locke stated, "Hey, I therefore took it firmly in my hands with all the expectations and read it through with all the attention to a treatise that made such noise at it coming abroad. I cannot but confess myself mightily surprised that in a book which should provide the chains for all mankind, I should find nothing but a rope of sand, useful perhaps of such, whose skill and business it was to raise a dust. It would blind the people, the better to mislead them, but in truth, not of any force to draw them into bondage, who have their eyes open, and so much sense about them as to consider that chains are but an ill wearing, how much care soever had been taken to file and polish them." So we believe that it doesn't matter what care had been taken to file and polish the chains, they could not bind anybody who was open, who could see. So Locke criticized Filmer's position in the first treatise on government. So he actually tear it apart in the first treatise on government. And then the second treatise on government, he created his own treatise. And this treatise revolves around the idea of a social contract and natural rights. He contends that political authority is derived from the consent of the governed, not the divine right or inheritance. Locke asserts that individuals have natural rights to life, liberty, and property. Does that sound familiar? And that the purpose of government is to protect these rights. He criticizes the absolute power of monarchs and argues for a system of government based on the consent of the people, with the ability to replace rulers who will violate their rights. And Locke's work is among the most important body of fundamental law. Now, most of Locke's words were read by the founders, and in fact, Thomas Jefferson, in the penning of the Declaration of Independence, got most of his thoughts on the subjects from Locke, which is very important because if you read the end of the second treatise on government, it tells you how to dissolve government, which has been hidden from us. But let's read one of the sections of that second treatise. The reason why men enter into society is the preservation of their property. And the end of why they choose and authorize the legislature is that there may be laws made and rules set as guards and fences to the properties of all the members of society, to limit the power and moderate the dominion of every parted member of the society. For since it can never be supposed to be the will of the society that the legislative should have a power to destroy that which everyone designs to secure by entering into society, and for which the people, submitting themselves to legislatures of their own making, whenever the legislators endeavor to take away and destroy the property of the people, or to reduce them to slavery under arbitrary power, they put themselves in a state of war with the people, who are thereupon absolved from any further obedience, and are left to common refuge, which God hath provided for all men against force and violence. Whensoever, therefore, the legislative shall transgress this fundamental rule of society, and either by ambition, fear, folly, or corruption, endeavor to grasp themselves or put into their hands of any other an absolute power of the lives, liberties, and the states of the people, by this breach of trust they forfeit the power of the people, and put into their hands for quite contrary ends, and it devolves to the people. Very important words. It devolves to the people, who have a right to resume the original liberty, and by the establishment of a new legislature, such as they shall think fit, provide for their own safety and security, which is the end for which they are in society in the first place. Remember last week we were talking about Frederick Bastier's words and how he said that the only reason we have a collective force is the preservation of individual liberties. And this is in line with the same reasoning. But tonight we're going to actually prove in the law this notion that we can step in and push them out. So tonight's question, which was supposed to be debate, but I stopped that from becoming a debate because it was so much information. We couldn't have time for the debate. So I built the debate or the answers into this presentation. Please take notice that as trustees and servants, you're at all times amenable to the people. Please provide clarity about where you were granted the lawful authority from creation to enter treaties with foreign powers, such as the World Economic Forum, the United Nations, the World Health Organization, that violate provisions of the Constitution and the sovereignty of the people. So the state, sovereignty, and the government. Government and the state are two separate entities. And I bet most of you didn't know that. Most of you, when I say the state, you probably believed that the state had something to do with the government. The government works for the state. And the state, in turn, is the people as individuals and not anyone serving in government. So this is from Black's Law Dictionary, the definition of a state. A people permanently occupying a fixed territory bound together by common law habits. Remember that, because when people say they're bound together by law, what type of law? Well, the common law. And custom into one body politic. So remember, these people are the body politic, exercising through the medium of an organized government, independent sovereignty and control over all persons and things within its boundaries, capable of making war and peace, and enter into international relations with other communities of the globe. The organization of social life which exercises sovereign power in behalf of the people. One of the component commonwealths or states of the United States of America. The term is sometimes also applicable to agencies authorized by states, such as municipal corporations. So sometimes a municipal corporation will be called themselves a state, but it's not the same kind of state. We, the people, are the state. The people of a state, in the collective capacity, considered as the property wronged by a criminal deed, the public as entitled of a cause, the state versus A and B. So the people are the state, as you can clearly see. Now, it also said in the body politic. So let's look up the body politic in Black's Law Dictionary. Black's Law Dictionary said body politic or corporate. A social compact by which the whole people covenants with each citizen, and each citizen with the whole people, that all shall be governed by certain laws for the common good. So now that we know that, it looks like there's two different types of individuals we're talking about here. They talk about people and citizens. So what is a citizen? A member of a free city or jural society possessing all the rights and privileges which can be enjoyed by any person under the Constitution and government, and subject to the corresponding duties. Citizens are members of a community inspired by a common goal, who in association relations submit themselves to rules of conduct for the promotion of general welfare and conservation of individual as well as collective rights. And collective rights obviously are the rights that are going to secure the individual liberties. Other than that, there are no collective rights. A member of a nation or body politic of a sovereign state or political society who owes allegiance. So here's, because, definitions have multiple different terms and multiple different meanings. Listen to this one. One of the sovereign people, a constituent member of the sovereignty synonymous with the people. So we're talking about body politic and citizen are synonymous with the people. See, we have all political power. So there's a lot of talk about who's the body politic. Well, the body politic, according to this, is the people. Because the people have all power, as you'll see in a minute. And we are the state. And there are two classes of citizenship under American law. The state citizenship, which is found in the U.S. Constitution prior to the Civil War, regarding, you need to be a citizen, representative, in order to be a representative, senator, or a president. This is a sovereign class created by and endowed by the Creator. But there's also a federal citizenship, 14th Amendment citizenship, which was defined in the Civil Rights Act of 1866. This is a statutory creation, so they're not the same. So when this refers to a state, or if you're in a right in a state, and it's talking about a citizen, it's talking about the sovereign. If you're in the federal government, it's talking about a citizen. It's talking about the fiction, the statutory fiction. Just want to make that differential. Now, I told you state and government are separate. Government is usually a municipal corporation. But here's what it says for Republican government. One in which the powers of sovereignty are vested in the people and are exercised by the people, either directly or through representatives chosen by the people to whom those powers are specifically delegated. Remember, John Locke said at the beginning, and I forget what the line is. The line is something like, by this breach of trust, they forfeit the power the people are put in their hands, and it devolves back to the people. Well, that's what this means. So in a Republican government, we have the ability we can do things directly, or we can do them through our representatives. So when our representatives, who we gave those powers to, mess up, we can throw them out and do the powers ourselves. Very important to understand. We don't lose the native rights we have. Even if we delegated them, we can take them back. So let's look at some Supreme Court rulings that talk about sovereignty, to put to bed any rest, and to put to rest anything that they can come up with, because this is what the deep state uses, right? They use case law. At the revolution, the sovereignty devolved on the people, and they are truly the sovereigns of the country. But they are sovereigns without subjects, with none to govern but themselves. The citizens of America are equal as fellow citizens, and there's joint tenets in the sovereignty. Now, you must understand this Supreme Court ruling is Chisholm versus Georgia. Now, why? Because first of all, this ruling came about 1793. And this ruling is a ruling that they hide from the attorneys themselves. When they keep the key of knowledge away from the people, they keep this key of knowledge away from the attorneys as well. So the attorneys don't know that we're not sovereigns. They don't know that we're sovereigns without subjects. They've been lying to the attorneys, and the attorneys have been lying to us. But let's look at Scott versus Sanford. The word sovereign people are those who form the sovereign and who hold the power and conduct the government through their representatives. Every citizen is one of these people and a constituent member of this sovereignty. And here's Wick Woe. When we consider the nature and the theory of our institutions of government, the principles upon which they are supposed to rest, and review the history of their development, we are constrained to conclude that they do not mean to leave room for the play and action of purely personal and arbitrary power. Yes, this is recorded. That person who's asking, yes, and it'll be posted tomorrow. But sovereignty is itself, of course, not subject to the law, but is the author and source of the law. But in our system, while sovereignty or sovereign powers are delegated to agencies of government, sovereignty itself remains with the people, by whom and for whom all government exists and acts. And the law is the definition and limitation of power. It is indeed quite true. There must always be lodged somewhere, and in some person or body, the authority of final decision, In many cases of mere administration, the responsibility is purely political. No appeal lying except to the ultimate tribunal of public judgment, exercised either under pressure of opinion or by means of the suffrage. But the fundamental rights to life, liberty, and pursuit of happiness, considered as individual possessions, are secured by those maxims of constitutional law, which are the monuments showing the victorious progress of the race, and securing to the men the blessings of civilization under the reign of just and equal laws, so that in the famous language of Massachusetts Bill of Rights, the government of the Commonwealth may be a government of laws and not of men. For this very idea that one man can be compelled to hold his life or the means of living or any material right essential to the enjoyment of life at the mere will of another seems to be intolerable in any country where freedom prevails as the essence of being slavery itself. That's pretty powerful. Wicklow is very, very powerful. So now that we understand, and we should all understand by now, that we are sovereign, and if you have any question that we're sovereign, you notice it didn't say sovereign citizen. If you notice that we are sovereign, if you have any question, go watch it a couple of times. I think it's pretty clear. So now let's go on to the powers of the people then. If we are sovereign, what does that power structure look like? And especially after you listen to what the definition of a state is, this Massachusetts constitutional right that has been enumerated will mean something completely different to you now. The people of this Commonwealth have the sole and exclusive right of governing themselves as a free, sovereign, and independent state, and do and forever hereafter shall exercise and enjoy every power, jurisdiction, and right, which is not or may not hereafter be by them expressly delegated to the United States of America and Congress assembled. So in other words, we have all the rights, all the power, all the jurisdiction, except for those few little things that we delegated to the United States of America. So what about the state? Did we delegate anything to the state? We are the state. And the sole purpose of that state government is to secure our rights. Nothing more, nothing less. And if they can't do that, we need to throw them out and find people who will. Massachusetts Constitution, Part the First, Article 5. All power residing originally in the people and being derived from them, that several magistrates and officers of the government, vested with authority, whether legislative, executive, or judicial, are their substitutes and agents, and at all times accountable to them. We see a pattern here. So we the people have all the power. We the people are the state. And we the people have every power, jurisdiction, and right. I don't think this is ambiguous. Now, what about corporations? See, everyone talks about corporations, and I want to set the record straight about corporations. When people talk about corporations and say corporations are unconstitutional or the federal government can't be a corporation, yada, 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 that's bunk. Because municipal corporations are the means by which we allow the government to become the government, to organize. Maxim of Law 76J, towns and boroughs, municipal corporations act as if persons. Of course, Massachusetts Constitution, Part the First, says that Part the Second says every charter, franchise, or act of incorporation shall forever remain subject to revocation and amendment. So it doesn't matter which type of corporation it is, it can be revoked for bad behavior. That means the Starbucks of the world. That means these BlackRocks. That means all these corporations are subject to revocation. Massachusetts Constitution, Part 1st, Section 8, contends, in number 4, solely for the incorporation or dissolution of cities and towns as corporate entities, alteration of city or town boundaries, and merger or consolidation of cities and towns, or any of these matters. Subject to the foregoing requirements, the General Court may provide optional plans of the city and town organization and government under which an optional plan may be adopted or abandoned by the majority vote of the voters of the city or town, yada, yada, yada. What we need to understand is we can have corporations in government. And just because a government is a corporation doesn't make them evil or bad and doesn't make them need to be dissolved. What we need to concentrate on is who has all the power. It's the people. And we can dissolve governments. We can dissolve corporations. Now, the next portion of this is going to be about treaties. The power of the President of the United States to make treaties. Remember, it said that we have every power except the power that we delegated to the Congress assembled. Well, the President of the United States is not Congress assembled, is it? But if you look at the second paragraph here, it says, he shall have the power, by and with the advice and consent of the Senate, aka Congress assembled, to make treaties, provided 2/3 of the senators present concur. So in order for a treaty to be made, we have the president who has the power to create the treaty, provided 2/3 of the Senate concur with it. And a treaty is an agreement, league, or contract between two or more nations or sovereigns, formally signed by commissioners properly authorized, and solemnly ratified by the several sovereigns or the supreme power of each state. Personal treaties relate exclusively to the persons of the contracting sovereigns, such as family alliances and treaties guaranteeing the throne to a particular sovereign and his family. None of that rest of that is important. What we need to understand is the government can come up with a treaty, and the treaty is a contract between two or more nations. But when can these treaties be dissolved, or when are these treaties not enforceable? Public treaties can only be made by the sovereign superior powers by the sovereign who contract in the name of the state. Now, this is from Law of Nations. This is the Law of Nations, also known as the Law of Nature. And the Law of Nature is in Article 1, Section 8 of the Constitution. It's protected. We gave Congress the authority to provide punishments for offenses against the Law of Nations, because the Law of Nations stands as fundamental law. So if we're going to fight against foreign powers, it behooves us to know what's in the Law of Nations, because we're going to be able to find all the ammunition we need to go after them. So here is saying that we do have authority. They do have the authority to make treaties, right? But a treaty pernicious to the state is null. So if something is against the state, there's no obligation for anybody to follow it, because no conductor of a nation has the power to enter into engagements to do such things as are capable of destroying the state, for whose safety the government is entrusted to him. The nation itself, being necessary, obliged to perform everything required for its preservation and safety, cannot enter into engagements contrary to its indispensable obligations. So if we believe that entering into the United Nations treaty is destructive to the United States of America, that treaty is null. And I believe that the treaty is null because it is destructive to the United States of America. And any future treaties with the WHO or the World Economic Forum or any of their bidding is treason, and these treaties are null. Law of Nations, Chapter 12, Section 161, a nullity of treaties made for an unjust. For the same reason, the want of sufficient powers, a treaty concluded for an unjust or dishonest purpose is absolutely null and void. Nobody has a right to engage to do things contrary to the law of nature. Thus, an offensive alliance made for the purpose of plundering a nation for whom no injury has been received may, or rather ought, to be broken. Most of what we're getting in our nation today, in terms of transgender agendas, come from the United Nations. And most of those agendas are contrary to the law of nature. And those offenses contrary to the laws of nature then make it a nullity. And anybody cooperating with the laws, these treasonous entities are committing treason themselves. Now let's look at the Supreme Court. There is nothing in this language which intimidates that treaties and laws enacted pursuant to them do not have to comply with the provisions of the Constitution. So if we go back to the original question at hand here, where were you granted the lawful authority from creation to enter treaties with foreign powers such as the World Economic Forum, the United Nations, the World Health Organization, that violate provisions of the Constitution and the sovereignty of the people? I contend that with this class today, we proved that we, the people, are the sovereign. We are the state, that we hold every power and jurisdiction, and that when the government enters into a treaty that violates the laws of nature, it's nullified. It can be nullified. So this is what we're talking about when we're creating notices. I just laid out the argument that could be put in a notice against the United Nations, World Health Organization, World Economic Forum in great detail. As far as corporations are concerned, all corporations are subject to applicable law, which includes all applicable provisions of constitutions, laws, statutes, ordinances, rules, treaties, regulations, permits, licenses, approvals, interpretations, and orders of courts. All government authorities, as well as all orders and decrees of all courts and arbiters. Every corporation is subject to revocation and amendment when they violate applicable laws. Is Tina in the house? Yes, she is. Okay, Miss Tina, do you have anything to say to me? Anything to add, subtract, multiply, divide?
No, I thought that was really good, though, Ron. That was awesome.
You have nothing to add? Nothing comes to your mind? I didn't leave anything out? You don't see any holes in anything I presented?
Nope, not right now.
Wow. Okay, well, I'm going to open it up for discussion. And before I do, I just want to say that we'll have a couple of minutes discussion before I shut this off. It's more important that you understand the what we're going to be talking about tonight. Next week, you should be very excited. Next week, we're going to start introduction to notices. So we're going to take this information that we've been learning over these weeks and start putting them into notices. So you can understand the language of the notice, why the notice is written the way it is, and how you can construct one yourselves. And that's next week. So all the joy of next week. So I'm going to open it up for discussion. Anybody who wants to join in the discussion, I'm going to unmute people now. Anybody want to join in? Just put your hand up and we'll call on you.
Good, thanks.
Okay.
Oh, can I give you my card? Oh, can I get a large straw? Thanks.
Okay, if you're in a drive-through or something, just can you mute?
Your comments about.
Anybody have any comments? Ed, you trying to say something?
Can you hear me or no?
No, very low.
Okay, let me work on it.
Anybody else?
Yeah, Ron, I have a question. It's John Serena.
Hi.
Was there a point in time in which we as sovereigns acted in this fashion, where we remove the government and actually do what the Constitution allows us to do, and then it sort of dwindled away? Is there any recording of, maybe in the late 1800s where sovereigns actually did this? And
Yes.
actually, when was the last time it was prominent or useful or common?
I will actually have to get that information because it's actually front and center with something that a group of people are working on right now to actually restore us to that time in history. So there are a group of people who are using notices and affidavits to restore that particular power to the people. Even though we already have that power, the vast majority of people don't know we have the power, so it's very difficult to understand. And not only do the vast amount of people don't understand, the people in law enforcement don't understand.
Right.
So we are slowly getting back to that time of history when that's going to be a thing again. But even all of the rights and powers that are outlined in the bills and declarations of rights, you can see exercised. I went back and I looked at redress of grievances written by John Adams. I went back and found all of those documents in history, so I could see how they did it, and they're all there.
Right. Well,
So.
if one were cynical, they would think that there was a purposeful effort to hide or at least repress.
And there actually was.
Yeah.
Woodrow Wilson primarily.
Right.
Woodrow Wilson started us down this path with the signing of the Federal Reserve Act, but he also was trying to take away founding fathers and founding history from our school systems, so that kids would no longer know what we're learning today. And progressively, that's what they did.
But they would be good employees.
We would be good employees. Well, that's exactly what the compulsory education system turned us into,
Right.
because that's also what they took over in the early 1900s. They took over compulsory education, and it was based on the school system of Johann Fichte, the Prussian model, where he said the school must fasten the child and fashion him in such a way that he simply cannot will other than we wish him to will. And that sounds about right, right?
Yeah.
And I
The
just,
people-
you
Go
know,
ahead.
if you look back in history, especially like in Massachusetts, and you look like Ron said, like the redresses, they would actually go right into the general court, which is your state legislator, and they would address grievances there, and your state legislator would fix the issue. And then that just stopped abruptly. And I want to say here it was like the early 1900s where they stopped it, but that was the process.
And we've been slowly being taken away from our birthright and our rights since then. Not that the rights disappeared, but our understanding of them did.
Right.
The Constitution's always been there. The Declaration's always been there. We just have not understood it until necessity jammed us into the position where we had no choice.
So, Ron, we have a question. Is one who became a U.S. citizen from a foreign country also able to be sovereign?
Well, the problem with in this particular fiction, a U.S. citizen is not a state citizen. So I don't know if that's something they can get. They can get the national, your state national, and that might be something they talk about. But typically, I stay away from the state national idea. But we are citizens of our state, and the federal government was not supposed to be. We're not supposed to be citizens of the federal government in the way that they've made us citizens of the federal government. It's all fraud.
I think once you become an inhabitant, like a true inhabitant, which is supposed to be really a property owner of the state, you gain some of those rights too. Do you recall that, Ron?
No, but we can look it up. Because I'm sure she's not the only person who's going to be asking that question. But we all are, they're all trying to pose that question anyway. If you don't know any better, they're going to try to call you 14th Amendment citizens anyway. Which you are not.
May I?
Sure.
Hi, my name is Leslie, and I'm from Missouri. Talking about the inhabitants and citizens. In the Law of Nations, Book 1, Chapter 19, subsections 212 and 213, they do define those. Thought maybe you could talk a little bit about that.
And what you said the chapter was?
Chapter 19, Book 1, subsections 212 and 213.
Can anyone in the background please mute if you're not speaking?
Okay, why don't we put that inside the chat, and we'll actually talk about it in like 2 weeks from now when I do the follow up on this class. So just put it in the quote so I can reference it. That way I don't bore everybody while I'm trying to go through and find it inside the Law of Nations.
Okay, I'm on the phone, so I'm not in the chat. So.
Okay, so what is it? What is it again?
Book 1, Chapter 19, subsection 212 and 213. And, if you want to talk about it at a later date, that's fine.
Yeah, in a couple of weeks, we're going to be doing the notice on this particular topic and writing a notice for tonight's class. So we'll bring it back up and we'll clarify it then.
Perfect. Thank you.
Yep.
So, Ron, how would you make it clear that you are not a 14th Amendment U.S. citizen, but rather a citizen, if you will, of the territory that you inhabit, the state that you inhabit?
Well, that's what we're going to be talking about next week, because all of our notice start with that language. And that's why the language is in that notice the way it's written.
Okay.
And we refer to ourselves as one of the people, as in the 50 state constitutions. That's why it's written that way.
Oh,
You're
yeah.
distinguishing right out of the gate who you are.
Because every federal form that you see that they want you to sign, you're swearing under penalty of perjury that you're a U.S. citizen. That's a 14th Amendment citizen. And they interpret that as a contract. And because you signed the contract, then that's what you said what you meant, or you meant what you said.
Yeah, so you can cross that out.
Okay.
So you can cross it out, and you don't have to sign any contract that doesn't fit your information. In fact, when you go to the hospital, you should always print out the hospital contracts and read them for yourself. You'll be surprised what you find.
Yeah, I've got the link to a place where you can go customize the directive that you can get put into your medical record and have advocates take with you if you're ever hospitalized. It makes all of that perfectly clear, that they're not to do certain things, and if they do, they lose their license.
Yeah, Ed says you can sign at UCC. I stay away from UCC because UCC is their code, and I don't want anything to do with their code. I stay complete in common law.
Interesting. Okay. Can you hear me now, Ron?
Yeah, now I can. Yeah.
Okay.
Yeah. There are a lot of people who talk about UCC, and I stay away from it. I don't deviate in any way, shape, or form from the common law.
Well, the trick is, I think you have to declare in what form you are showing up or participating in whatever form, right? And you do that by saying a member of We the People.
I say I'm one of the people I've seen in the 50 state constitutions, Republican informed sui juris.
Yep.
So that they can't say they don't know. And it doesn't matter if they're trying to make us a corporate democracy or whatever else that they're trying to get away with. I don't play into any of that fiction because it's all fraud. They never had the authority to do what they're doing. So why would I recognize their authority?
Mm-hmm.
They didn't have it. They don't have it. They're my servant. My servant can write a whole bunch of laws and fake policies in my company. Am I going to honor it?
Right.
So
well, I've always, I follow a lot of people that talk about the whole corporate versus de jure government forms, right?
Yeah.
And I mean, and you're right. I mean, like even these auditors, on YouTube, trying to educate cops as to what their true jurisdiction is. That, in essence, because they're working, there's a side of the argument that says because they work for a corporation, it's like, it's no different than Chuck E. Cheese employee that he's carrying cups, a gun, and right, and that they are in essence at war with We the People because of the approach they take to enforcing statute, right?
So let me ask you a question. Where are they claiming to get their authority from?
I think they're doing what they're told. Most cops have no clue what their jurisdiction is.
Like the governor, for instance, the governor will come out and she'll say something, and by what authority is she saying that she is making that rule or whatever?
Simply by the authority of her office, which she's omnipotent.
Okay, so she's doing under the authority of the Constitution. She makes executive orders that cite the Constitution. Did you know that?
No.
So when they make executive orders, they're citing the Constitution, which is the derivative of their power. So how can they deviate from the document and still derive the power from the document?
Well, that's the thing. They can cite the Constitution, but if what they're doing is at odds with the Constitution, then it's a quantum. It's
right.
illegal, I'm sure. Yeah.
So John Locke says when they do that, they dissolve their own office. And that means they are no longer in office. And that is true in most of the cases. They just don't know it.
Who's going to drag them out?
Well, this is the problem when you have lawlessness. When you
Right.
have criminals who don't follow the law in office, this is what it looks like. And you have ignorant people following the lawlessness who are supposed to be protecting the people, i.e., the sheriffs.
Correct.
So this is the nation, this is the state of our nation. And it's because most people did not wake up and assume their rightful position. They don't know who they are. They don't know their power resides in themselves. Is there any question based on what I presented tonight who has the power?
No.
Is there any ambiguity? Was I
Nope. The only question is who enforces that, right? Because we're supposed to be stalemate, right?
It's supposed to be the sheriff and we, the people, as the militia. That's what's supposed to happen.
Right.
And but the sheriff is supposed to call that militia. But that's not what's happening. And we're supposed to be able to prosecute our own claim, and we're supposed to be able to create our own court. And that's happening behind the scenes. And the government that's in place is being brought back in line behind the scenes as well. Like I told you, weeks and weeks and weeks in a row about what's happening in the Supreme Court and what's happening all across the nation with notices and affidavits.
Right.
So the best thing we can do is to load them up with notices and affidavits and get them under tacit agreement so that when the system flips, they have nowhere to go.
Right.
Okay, I'm going to stop the recording and then I'll still open it up to the rest of the people who want to talk. Hold on a second.